This is one of the seminal cases from Ghana's Supreme Court on labor matters. All courts follow the Supreme Court on point of law, so when the Supreme Court speaks, we must pay attention. The Constitution of Ghana provides that every person shall receive equal pay for equal work. It was in that spirit that 93 casual workers of Ghana Breweries Limited, led by Sebastian Jaisu, sued their employer. They were casual workers, but they claimed that they did the same work as the permanent workers and did not get the same packages. Under a collective bargaining agreement, the permanent workers enjoyed night allowances, annual leave, back pay, overtime, and the like. Sebastian and his colleagues got none of that. They wrote petitions to management and they knocked on the doors of the Labour Office, but all these efforts were fruitless. So they sued, telling the High Court that they were being unfairly treated, and that they were doing the same work on different terms, and that this was discrimination of the most unjust and unconscionable kind. They wanted every benefit the regular workers received under the CBA. They asked for 200 million cedis in damages and a court-appointed expert to calculate every cedi that they were owed. The trial came, and Sebastian climbed into the witness box to speak for all of his colleagues. He told a very compelling story of spending years as a casual worker, moving from the raw material section to the bottling section, working the same shifts as regular workers, but never receiving the same benefits. Under the weight of cross-examination, things began to shift. Sebastian admitted that he was not covered under the CBA. He further admitted that casuals were distinct from regular workers, but only prayed that after 6 months, he should have been elevated and upgraded to permanent status. Meanwhile, Ghana Breweries called their company secretary and personnel manager. They told the court plainly that it was not true that the casual workers did the same work as permanent employees. Permanent workers were skilled, highly trained professionals who operated sophisticated equipment. The casuals only swept floors and packed crates. And even then, they were not mistreated. They received medical attention and also received subsidized meals. The Supreme Court, speaking through the respected Justice Sufaya Dinyora, was direct. Sebastian had claimed that he and his colleagues did the same work as regular workers. The company denied it, so Sebastian had to prove it. Instead, he mounted the box and repeated the same bare assertions from his documents. He called no one to corroborate his testimony. He gave no details, no specifics, no rosters, no job descriptions. No colleagues were called to corroborate. Just the same bare assertion repeated that we did the same work. The ancient principle remains unyielding, that he who alleges must prove. Sebastian and his colleagues had simply failed to prove that they did the same work. That argument was lost. The court then turned to the next issue. Sebastian argued that having worked for more than 6 months, the law required their graduation to permanent status. That would unlock all the perks that came with it. It was a compelling argument, but it was not the position of the law, and even Sebastian's own lawyers admitted it. A casual worker under Ghana's Labour Act is an employee engaged in seasonal or intermittent work, not exceeding a period of more than 6 months, paid on a daily basis. The law does not make it mandatory for an employer to convert a casual worker to a permanent employee. It does not even require that casuals receive written contracts. Perhaps they had confused their status with that of temporary workers, a completely different category under the law. Temporary workers are those employed continuously for at least 1 month in non-seasonal work, and they are entitled to be treated as permanent workers after 6 months of continuous service. But Sebastian and his colleagues were at all times casual workers, a completely different legal category altogether. The CBA did contain a provision for automatic conversion after 6 months, but it did not cover casual workers. There was zero basis in law or in contract for their request, and that ground also failed. The court finally turned its attention to the CBA, the collective bargaining agreement. The CBA had been signed between Ghana Breweries and the ICU of the TUC of Ghana. Sebastian and his colleagues were not members of that union and were not covered by the agreement, but their lawyers had one more card to play. They argued that by law, the ICU was required to represent all industrial workers in the company, casual or permanent, and the CBA itself stated that it applied to all employees at the time of signing, and any new employees who came on board thereafter. The phrase there was all employees, and Sebastian's lawyers leaned hard on those 2 words. The court looked at the entire document and disagreed. Every employee contemplated that the CBA was required to be a union member. Sebastian and his colleagues were not. The CBA also described very elaborate and formal processes for new employees. They received engagement letters, probation, and appraisal-based termination. None of this bore any resemblance to how Sebastian and his colleagues arrived for work each morning. They were casuals who were employed on a daily basis at the gate of the company premises as and when work was available. They are not interviewed, they were not given any engagement letters, nor did they go on probation. So the expression all employees could not be stretched to cover them. These were people engaged casually day by day and who were free to go and come as they please, and whom the company was not even obliged to hire. The CBA was never intended to cover them. Sebastian Jaisu and his colleagues had lost at the High Court, at the Court of Appeal, and now at the Supreme Court. But Justice Adinira was careful to close with something important. Losing this case did not mean that casual workers were without rights. The law protects them on their own terms. They are entitled to equal pay for equal work on the task they perform, and they are entitled to medical care. They must be paid overtime, and if they show up and circumstances prevent them from working, like bad weather or no available task, they must still be paid for that day. Ghana Breweries had complied with all this, and in fact, before the matter ever reached court, they offered written casual employment contracts, but Sebastian and his colleagues turned them down. What do we learn from this case? You must know your legal category. Casual, temporary, permanent, these are not interchangeable labels, and they each carry different obligations. Second, in court, evidence is everything. A court cannot rule based on feelings, however genuine. You must provide specific proof of documents, witnesses, job descriptions, etc. Evidence is what wins cases, not emotions. Finally, you must always read the entire contract, not just two words that seem to favor you. Follow Super Law GH Studios for more. Real stories, real cases, real people. The case reveals a tension in labor law. If an employer hires you as a casual employee and just before 6 months he releases you and rehires you again, he may have complied with the law in keeping you casual, but in truth the continuity of employment inches you closer to permanence. If you keep hiring the same person over and over and over again in a pattern that feels like continuous employment, the label of casual becomes very meaningless. The person becomes a permanent worker dressed in casual clothing, perhaps because it might be cheaper and less burdensome to keep them as casual. But what do you think?